Good morning, everyone. It's
Morning.
Wednesday. We love Wednesdays because Wednesday we get to do simple procedure, and boy, do I have a treat for you today. Default judgments. But first, what's happening in the legal universe? Well, in the Ninth Circuit, Court of Appeals, you guys know where the Ninth Circuit is, right? Where's the Ninth Circuit? Somewhere that way? Yeah, no, not east. The opposite
West?
one, the other one. Yeah, west. Right, the northwest. Right. California, and some other states that aren't California.
Oh yeah, the one Trump doesn't have a good time with.
Yeah. It's got a reputation for being the most liberal of the circuit courts of appeal, which is rather like being, I don't know, the prettiest mutant in the swamp or something, I don't know. Look, what happened here was cops get sued under a statute we've already talked about just briefly in here, 42 U.S.C. 1983 for a constitutional violation, Fourth Amendment violation for stealing $225,000 in the course of arresting these gentlemen in California. Cops file their answer and file a motion for summary judgment, both of which have an argument about qualified immunity in there. All right, qualified immunity essentially is, we know this because we know what affirmative defenses are. It's an affirmative defense that says, all right, fine. Even if we did it, you can't hold us responsible for it. Right? And why? What's the basis of the qualified immunity argument? It's because under the qualified immunity doctrine, for someone to be held responsible, for a state actor to be held responsible under the Constitution, the law must have been clearly established under the Constitution. Some prior case must have clearly established that what you were doing was wrong. And what the Ninth Circuit Court of Appeals has said here is that the law didn't clearly establish that stealing $225,000 from someone in the course of an arrest violates the Fourth Amendment. No way a reasonable officer could have known that. So is that really what they say, Professor Cannon? Or are you blowing this out of proportion? No, go read it. That's really what it says. Yes, go ahead.
That sounds like the most asinine opinion I've heard. That's the most asinine opinion I've ever heard in my entire life. How can any reasonable officer not know that, yeah, maybe you shouldn't steal from people you're arresting?
Wait till you take my civil rights class. I will introduce you to even more asinine opinions. But this one, I agree, is pretty asinine. It's one of those things that that things are not always what you think they ought to be in the law. This is why researching and looking up the law and doing the kind of things that you're going to be wanting to sort of blow off when you get into practice, because you think obviously the answer is X, and you look it up in Westlaw and you find a case like this that says no, actually the answer is Y. Yeah, Neil.
Should we have sued them in their private capacity?
They were sued in their individual capacity. There is no other way to sue someone for money damages under the Fourth Amendment. You must sue them in their individual capacity. Qualified immunity is only an affirmative defense that applies to a defendant in their individual capacity. We're going way off the deep end here, but that's the only way. Otherwise, you're suing the state. Qualified immunity doesn't apply to the state, but the state is immune. Yeah.
So did they steal it after they already searched? Or was what was the Fourth Amendment issue?
So, yeah.
Obviously that's not stealing.
So basically, the Fourth Amendment issue at its core is these guys get arrested. During the course of the arrest, they seize $275,000 worth of stuff, but only report that they seized $50,000 worth of stuff. Right?
Different if they were sued strictly for the theft and not for like the theft of property and not for the Fourth Amendment violation.
Maybe. That's an issue of California law. That's an issue of California. Yeah, I don't know. I don't know. I would assume that there is a tort that would apply, and maybe the case still goes on. I don't know. What the California federal court has said, or what the federal circuit court has said, is that this was not clearly established law. And the procedurally interesting thing here is that the court doesn't make a call as to whether or not this kind of behavior is constitutional. So it doesn't help anybody that comes afterwards either, right? So our Supreme Court, in its infinite wisdom, has said that you can make a call as to whether the law was clearly established or not, right? Without making a call as to whether or not the thing that we're even talking about was constitutional in the first place. Counsel?
Is IRS gonna go after them? Or is
I
it
mean,
still
no.
money?
I don't know. Let me peer into my crystal ball that tells me all the secrets of the IRS. And I'm going to assume no, because they don't go after anybody, right? Except for somebody that they're really mad at, and certainly not police officers. Yeah. The interesting thing here, and I think all of you probably know this by now, you have to sort of use your lawyer brain to translate what reporters write about the law sometimes, right? Here they're saying Jessup and Ashtian, those are the plaintiffs, have appealed the decision and petitioned for their case to be heard in front of the entire Ninth Circuit. Well, they haven't really appealed their decision, but they have petitioned for their case to be heard in front of the entire Ninth Circuit. And what is that petition called?
En banc.
Yeah, a petition for en banc review. Right. You've heard of this before, right? So they argue the case. The original case gets argued in front of a panel of 3 judges, just like most of you did for your first year oral argument. Right. They don't like that opinion for obvious reasons. They turn around and say, well, we'd like for the entire Ninth Circuit, all the judges on the Ninth Circuit Court of Appeals, to sit and hear the case. Got a decent shot at it, although those are very rarely ever granted. Questions about any of that horrible stuff? No? All right. Well, then on to default judgments. Rule 55. Starting with our introductory problem. And the introductory problem gives you this particularly egregious set of facts that, much like it being perfectly constitutional to steal $225,000 from someone, we don't really want to accept as true in the legal universe that we may have created for ourselves in our mind at this point in our second year of law school. Right? Carter loans Clinton $1 million rather for 1 year, 5% interest. At the end of the year, she refuses to pay. Carter sues her. Clinton doesn't answer. Assuming the summons was properly served, right? Assuming service of process was effectuated properly. Court clerk enters a default judgment for $1,050,000. $50,000, of course, reflects the interest. Right? Is that okay? Is what happened here okay, or is something wrong with it? Could this be a thing that actually happens in real life practice? Yes.
Doesn't don't they have to issue an affidavit, like show, like, in addition to the open notice saying that?
No.
Well, then just-
None of the federal rules. None of the federal rules. Anything else? Yeah.
Can't clerks only enter in judgment if it's like very, if the amount is like certain and there's no, it wouldn't be up to like the discretion of the judge or anything?
Is there anything like that that suggests that it's not a certain amount? I mean, you're right. I agree with you. This isn't a personal injury case. I don't know. Let's say a battery case. Something like that. So I don't think that's wrong. Go ahead.
The court clerk can't do that, like, on their own, they need promotion or
Well, yes.
Carter.
Yeah. Assuming that the plaintiff did something positive to make default judgment, took some affirmative action to make default judgment happen, right? Anything else that we can pick apart here? In fact, this is perfectly fine. If you are the plaintiff, collect your $1,050,000. You win. Congratulations. That's it. Right? That's it. Wow. What? What? Really? Yeah, it really is that simple. Let's make some slight modifications here. See what we think about that. What if the defendant had entered an appearance and filed a motion to dismiss? File a motion to dismiss, 6 months goes by, there's no ruling from the court on the motion to dismiss, that's still hanging out there. And there's no answer that's been filed by the defendant. You haven't filed a responsive plea. So can you then move for default judgment if you are the plaintiff? Yeah.
Does it depend on what happened? Like, for example, if they did file a motion to dismiss, but somehow it got lost and no one saw it, and then that just seems like they didn't answer at all, and so the clerk enters the default. Like, I feel like that could happen.
Yeah, that's a different scenario. Assuming everybody has seen the motion to dismiss. So, I mean, if they file a motion to dismiss, and we're talking about paper filing and not electronic filing, and, I mean, that gets us down a whole different rabbit hole, right? But let's assume that they filed a motion to dismiss and it got lost someplace, and then the default was entered. Well, then I think the default was probably improperly entered. We'll talk about how to deal with that situation, too. But assuming that the motion to dismiss got there, yeah, Brittany.
Okay, so just a quick question.
Yeah.
So like, if you file an answer and to where you like deny all of the claims, is that, I know that it's not procedurally the same as a motion to dismiss, but could you like put like a prayer for relief in the end saying like, could you do like something like that, like dismiss it with that answer? Like move to dismiss it with that answer?
You can assert you can and should. Well, you've drafted an answer. You can't. I'm not sure I understand your question. You can and should assert your affirmative defenses in your answer. Like you must do that, right?
Well, yeah, I get
And you
that.
can assert some of those affirmative defenses. Look at 12B, but you can assert some of those affirmative defenses in a motion to dismiss.
Okay, I think what I was looking at is like, would it be the same to enter a motion to dismiss and then like, would that be the same as answering a complaint with like deny, wherefore dismiss this?
That is kind of what I'm asking you, right?
Okay, I think
That's
that's
kind of what I'm
better.
asking you. That's sort of I think I understand it. I think that's the heart of my question. Is this going to keep the plaintiff? Is that motion to dismiss by itself going to keep the plaintiff from getting a default judgment? Who says yes, it will? You can't apply for a default judgment under these circumstances. Who says no, you absolutely can apply for a default judgment under those circumstances? Pursuant to what authority? Once there's something filed, this is the thing to remember. This is what I was afraid maybe your book was a little bit confusing to you about. And the rule itself is not super perspicuously clear, right? Once there's something filed, you're not going to be able to go back and get that default judgment. If it's out there, if there's a motion to dismiss, if there's a dispositive motion hanging out there for a judge to decide on, you're not going to get your default judgment. Not going to happen. I don't care how long. I don't care if it takes the judge 2 years to rule on that motion to dismiss, and there's no answer filed. The defendant doesn't have to file an answer while that motion to dismiss is pending. Okay? They don't have to, unless they've been ordered to. They don't have to. You don't get a default. Now, if the defendant loses the motion to dismiss in the second month, 4 more months go by, and the complaint hasn't been answered yet. All right? The way this plays out, file your motion to dismiss. Motion to dismiss, a judge enters an opinion on the motion to dismiss and says, no, I'm not going to dismiss the case. Okay? File your answer. Even if the judge doesn't say file your answer explicitly in the opinion. 4 more months go by, no answer is filed. Can you seek a default then? You say yes. say no. Say no. Anybody not sure? Probably about where we want to be. Hard to question. Yeah, you can. You can. You can under those circumstances. Okay. That's not likely to happen. Right? It's not likely to happen. And in your book, there are all these sort of arcane and esoteric things that are addressed that happen very rarely in practice. If somebody has already entered an appearance and filed a motion to dismiss, you can be pretty sure they're going to file an answer after they lose that motion to dismiss. Right? Maybe not. But the fact of the matter is that even if they don't, you file your default judgment, then what's going to happen? The defendant's going to be like, oh shit, I forgot to file my answer, and they file their answer. Right? They move to file the answer out of time. The judge will 99.9% of the time grant it, because that's something that's well within the discretion of the court to do. And judges don't like default judgments. They don't like them. What did you learn from Deskins? I don't want to jump ahead too much, but what's the point of Deskins? Is there anything improper about the way the plaintiff sought the default judgment in Deskins? Pay attention to my question. Was there anything improper about the way the plaintiff sought default judgment in Deskins? Did you read Deskins? Did you understand Deskins? Is there anything improper about what the plaintiff did to ask for default judgment in Deskins? Yes?
In the terms of a contract, if it didn't know how much money to pay them in.
That pertains to the amount of damages that could have been awarded to the plaintiff. But in terms of just seeking the default judgment, is there anything wrong that they did? Neil?
Yeah, I'm sorry, I wasn't. But,
Thank you for your candor.
so, there wasn't any, the construction contract wasn't admitted. That should have been attached with the motion of summary judgment, or, a default judgment. Because basically the plaintiff just shows up and says, these are the damages, just trust me, and the court enters the default judgment based on that.
Right. Think of Deskins as occurring in two different components, right? And this realistically is the way the default judgment scenario plays out in court, in real life. The judgment is entered, and the judge will typically set a hearing on the issue of damages, right? So here in Deskins, what the court is saying is the judgment itself on liability is fine, right? Plaintiff didn't serve a copy of the motion for default judgment on the defendant. Did you catch that in Deskins? Didn't happen. What does the court say about that? Fine. 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 You don't have to. Right? You don't have to. But you screwed up the damages portion of this whole thing. Court. And maybe a little bit plaintiff, but mostly court. Right? That's what the Court of Appeals is saying. It's like, look, the way that you did this damages thing is so sloppy, you got to do it over again. Did they touch the default judgment as to liability? No, he's still liable. He's still liable. Even though the case gets reversed, the defendant is still liable. We just don't know what the amount is. And I say all that to say that I think what the court is basically trying to convey, and what most courts are trying to convey when you read opinions on default judgments, is that we don't really like this. We don't like doing it. especially not when somebody has showed up, even if it's at the 11th hour, to say, please don't enter this judgment against me. Okay? They don't really like doing it. And so the good news, if you're a defendant, is that in most courts there are plenty of ways out. Okay? What if the defendant had only filed a motion to strike? Any sort of appearance, any sort of filing, any sort of anything by a defendant is going to change the rules. Right? It's going to change the rules ever so slightly. So, in the situation where the Deskins type situation, the situation that you most often are going to get a default judgment and have it stick, where the defendant just hasn't bothered to show up and hasn't bothered to do anything. Right? Doesn't want to, just wants to pretend like the whole action doesn't exist. That's pretty easy. Then you get what we had in our introductory problem. File something with the clerk enters default judgment, that's it, you're done. Okay? Maybe you have to have a hearing on damages. Depends on what kind of action it is. If it's a personal injury action, got to have a hearing on damages. Still got to do that. Okay? Still got to do that. If they filed anything, then the rules change. Then you have to ask the court. Okay? It's simple. The defendant doesn't answer, move for default judgment. And almost always, even as we see in Deskins, this is a straightforward contract action, even though they haven't attached any of the contract stuff. You're going to have to ask for a hearing on damages. That is the safest way to play this. And I would suggest that even if you have the kind of situation that we have in our introductory problem, promissory note, $1 million, 5% interest, that's easy, right? Still ask for your hearing on damages. Still ask for it, okay? Keep it clean. Keep it clean. Because these are pretty easy to attack after the fact. And once you get a judgment against somebody for $1,050,000, they might want to undo that judgment. And you as the plaintiff, need to keep that as tight as possible, right? Make as good a record as you can below, so when they come back 2 years later and say, no, wait, that default judgment never should have been entered, you can say, look, here's all the hoops I jumped through, I followed the rule to the letter, we had a hearing on damages, the court issued an opinion from the hearing on the damages, findings of facts and conclusions of law are all there, time for appeal is gone, this is a good, solid default judgment. All right. The other side responds, but never files an answer. And I say, remember King pay-per-view that we talked about last class. What does the court order to have happen in King pay-per-view? Remember that one? The court is really pissed off at defense counsel for the way in which they answer the complaint. So what's the remedy that the court orders? In that case, just to refresh our memory, the court was mad enough to order all the allegations admitted by the defendant. And what's more likely to happen in a situation like that is that the court strikes the answer. The court strikes the answer, right? And then that creates the legal fiction that you have to look out for purposes of default judgment, creates the legal fiction that no answer has ever been filed. Does that make sense? Isn't this fun? But again, if anything has been served on you, if there's any indication whatsoever that the defendant is out there and alive and wants to defend this action, okay, you have to serve them with the motion for default judgment. You see that doesn't happen in Deskins. The rule allows you to get away with not serving it on the other side, but that's just what the rule allows you to get away with. The better practice is send it to them anyway. Send it to them anyway. Why not? Okay. Why not? Because you're looking 3 or 4 steps ahead in the future. You're trying to protect that default judgment that you get. And if you can come back to the court and say, when the defendant is jumping up and down and saying you never should have entered this default judgment, if you can go back to the court and say, look, the rules don't require us to even serve a motion for default judgment on the defendant under these circumstances, but we did it anyway, Your Honor. The other way that you rarely see somebody get a default judgment is if somebody's defending the action. This isn't really covered all that much. You don't see it that much. But if somebody is actually actively defending the action and refuses to comply with court's orders, especially on discovery. So I've asked for defendants' payroll records and in discovery, and they didn't turn them over, and so I filed a motion to compel, and the judge said, yeah, you got to turn them over, and they still didn't turn them over, and so I filed a motion to hold them in contempt, and the judge says, yes, you're in contempt, you really got to turn them over within the next 30 days, or something really bad is going to happen, right? And then after you've gone through all those procedural devices, 2 years later, you say, all right, well, I've really had enough here, and court, you should award a default judgment because the other side is being such an idiot that gigantic sanction is warranted. That's the fail to otherwise defend language that you see in the rule. Okay. They fail to answer, they fail to file a responsive pleading, or they fail to otherwise defend. So you can't just parachute into it. And for that reason, too, you can't just parachute into an action as a defendant, file your answer, and then refuse to participate in the rest of litigation. You'll get a default judgment entered against you eventually. Yeah.
I'm having trouble with the second middle one.
Mhm.
The difference between like responding and not answering.
Right.
Like, what's an example?
Filed something, right? Filed something, like file a motion to dismiss, for example. There may be a better way to say that than responded. So if the defendant has filed a motion to dismiss, but never filed an answer after the fact. Remember that hypothetical that we went through, where the defendant files a motion to dismiss, the judge rules on it, and then the defendant is technically obligated to file an answer to the complaint after they lose their motion to dismiss. See what I mean? If they don't do that, you could technically get a default judgment. You won't. Okay? 9 times out of 10, you won't. Questions about any of this stuff? This is easy, right? Easy. Simple. Right? We talked about most of this stuff from Deskins. Do we think that Deskins actually got served? Those of you who read the case? Yeah.
So I actually didn't really understand that because they went through the Secretary of State like they were supposed to, and they attempted to serve them, but he refused to sign for it like 3 times.
Yeah.
And that's sufficient service, like that counts as service. That was
What they say is that he refused to sign. he refused to accept it. Now, we don't really know the details of that. You know. But what the court looks at is, did you comply with the long arm statute? Did you comply with the rules? And they come to the conclusion that he did, without really much discussion. What else about that? How does the defendant try to attack the default judgment? How does that happen? Did you catch that?
Doesn't he try the same thing when he knows of the first hearing? I don't like the default.
That is what he says. What's the procedural device that he uses to attack it? Sort of buried in there. Might you want to know this, though, if you have a client that comes to you in a panic because they've had a default judgment against them? Hey. Brian?
Is it the 60.02?
Yeah, it's a 60.02.
Grounds of mistake.
Yeah, 6002. What we call a 6002. Right? 6002 says, please undo that stuff that got done. Okay? Please undo it. We discussed what happens to the judgment. What's the posture ultimately of this case at the end? What is the court order? We've said that the default judgment on liability itself remains untouched. Okay? So defendant is liable. And what happens? What's it been sent back for? Yeah. Say it again?
The damages.
The damages hearing, right? An evidentiary hearing on damages. So you screwed that up, court. We're not going to let that stand. Go back and figure out what damages really are. Anything else about that? What if this contract had an arbitration clause? Remember we talked about that when we were talking about our affirmative defenses? This is just fun to think about. And you're like, Professor Cannon, how can we have any more fun in civil procedure? There's just no way. And I'm telling you there is a way. By imagining an arbitration clause. So there's an arbitration clause baked into the contract that's at issue, or even go back to your introductory problem. There's an arbitration clause that applies here, that would apply, that would instead require the parties to submit to binding arbitration instead of going through the courts. Then, if that were the case, could the plaintiff get a default judgment? No. Then, then the answer is no. Yeah.
Would only like maybe only if the defendant is I guess not the arbitration respond.
If the defendant refused to go to the arbitration? So, my question though is, what happens if the plaintiff files this action in court? There's clearly an arbitration clause in the contract, right? Defendant doesn't answer, doesn't file any responsive pleading, just like in Deskins. Can the plaintiff then ask for the default judgment? Be prepared to justify your answer. Yes?
Yes, because it's a affirmative defense, they would have to win out.
That's right. Yeah, that's exactly it. Everybody hear her?
No.
Asserting the arbitration clause is an affirmative defense. And if you don't show up to defend the action, you can't raise an affirmative defense. The real question is whether or not the defendant has responded in any kind of way at all. And if they don't, you can get your default judgment. Okay? Arbitration clause or any other defense notwithstanding. Everybody see how we got that? Yeah. Okay, move on. What is considered against your client? The magic stuff here is 55C and 60B. Okay? Let's think about that for a second. 55C is real simple. The court has to say, the court may set aside rather an entry of default for good cause, and it may set aside a final judgment under Rule 60B. There you have that reference to 60.02 in the Kentucky Civil Rules. Same thing, 60B and 60.02, right? Remember how to do those conversion tables in your head. They're basically the same civil rules in most cases. Court may set aside an entry of default for good cause. What's good cause? What the court says. And if the judgment has been made final, then you can set it aside under Rule 60B. What's the difference between an entry of default and a final default judgment? What is the rule talking about? Yeah.
It's not final until the damages have been settled, is that right?
Yeah, that's right. I mean, it's not final until it's finally final, right? The judge enters a final and appealable order. And that can't be done unless and until damages have been determined. So think about Deskins. Deskins is a good example of this thing because Deskins really does treat it in two phases, which I think is mostly the way you will find it in the wild. You've got the court enters the default judgment on liability and says, all right, we're going to have a hearing on damages 6 weeks from now. You go and have your hearing on damages. During that entirety, during the entire pendency of that 6 weeks, and thereafter, until the court enters the final order on damages, there is no final order, right? Even though a default judgment has been entered, lots of judgments, you guys understand this for purposes of appellate practice, right? Lots of judgments get entered throughout the course of litigation, throughout the course of a civil case, criminal case, right? Lots of orders get entered. What's important is what's the final order? Right? Does that make sense? So you can enter a default judgment on liability, but if damages haven't been hashed out yet, that's not a final judgment. That's not a final judgment. So what this rule says is that, let's say the defendant discovers that there's been an entry of default judgment someplace in that 6 week period of time that we've been talking about before the final hearing on damages. Oh shit, a default judgment has been entered against me, which is exactly what happens in Deskins. And then what do? You represent that defendant, what do you do under those circumstances? You're in this 6 week twilight zone, there is no final judgment yet. How do you handle it? Kelly, you had something? No. You got to get your foot in the door somewhere to beg somebody to make the default judgment go away. How do you do it? Yeah?
Just do what Deskins did, drop on some of the 60.02 motion for when you messed up.
Deskins uses the 60.02 after the final judgment has been entered. We're not on that planet yet. Let's talk about where we are, where you're waiting for the hearing to happen. The hearing hasn't happened yet on damages. There's no final order from which you can appeal. Right? How would you do it? You're making it too hard. Yeah.
Is it just a motion to set aside?
Motion to set it aside. Motion to set aside a default judgment. That's it. That's it. File a motion to set aside the default judgment. And had you better put what your good cause is in your motion? Oh, yes. Yeah, you better. You better attach some affidavits and be prepared to show up on your knees for motion, right? And my computer's frozen. 60C, which I didn't assign to you, but if you look at 60C, it gives you a time frame basically. After that final judgment has been entered, let's just look at 60. After that final judgment has been entered, 60C says this is when you can ask the court to undo that final judgment. You basically have a year. Just touching on that real quick. Make a note to yourself. Now you can come back and attack a void judgment anytime. Right? And that's what's contemplated by Rule 60. You can attack a void judgment. What do we mean by a void judgment? When would a default judgment be considered void? Yeah.
And there's no jurisdiction.
There's no jurisdiction. It's really the only example I can think of. Maybe there's others. You get a default judgment against somebody and they haven't been served, or the court doesn't have subject matter jurisdiction, or the court doesn't have personal jurisdiction over the defendant for some other reason. That judgment is void. The court has to have jurisdiction over the defendant, over the subject matter, to be able to enter a judgment of any kind in the first place. Yeah.
I'm having trouble seeing what that looks like, because why would they enter a judgment if they didn't have jurisdiction? They're just gonna do it without analyzing that
Because
first?
courts are sloppy and run by human beings.
Okay, so they're gonna enter it,
Yeah.
and it's gonna seemingly be valid, but you're gonna say in your head, no, this is void, because they didn't have jurisdiction, and then what's that look like? Or is that right? Or how does
You're
it
talking about if you being the defendant? If
Yeah.
the defendant looks at it and says, no, this is void.
Yeah.
Yeah, I mean, you want to attack it at the earliest possible time that you can attack it. But if it's a void judgment, it can be attacked pretty much anytime.
I guess what I'm asking is like, at what point do you know it's void? You see what I'm saying? Like, they've entered this judgment.
Oh, if you're the defendant, it's always void.
Okay. Okay.
Right?
Yeah.
I mean, I don't know. That's
Yeah.
too fact specific. Right? It
Okay.
just depends on what happened. But the big way that it happens usually is when somebody, the plaintiff comes and says the person has been served properly, and in fact they haven't.
Okay.
So the plaintiff comes and says, there is personal jurisdiction here, you can go ahead and enter this default judgment, and it turns out, no, wait, there wasn't personal jurisdiction after all.
Okay.
Yeah, make sense?
Yeah.
You had something. Did I get it? Okay. Void judgment, that's important. So you got your money's worth this morning. All right. Problems, number 2 on page 485. Paul sues the city of Davenport. This is all stuff we've gone over, right? These principles we've gone over. So you've been awake for the last hour, you know the answer to this one already. Paul sues the city of Davenport for federal civil rights violation. The city is never served. Paul moves for a default judgment after filing his claim. Can a default judgment be granted? Does anyone say yes? Good, then we'll move on. No, the court doesn't have jurisdiction. The court doesn't have jurisdiction without proper service of process. Everybody see that? That's simple, right? Simple. Nobody's been served, there is no personal jurisdiction. If there's no personal jurisdiction, the court can't enter a judgment of any kind. Go ahead.
So my question is, what if it's another kind of like Thespians, like maybe the city attorney, whatever, wasn't served, but they went through the process until whatever there is, I guess, for the city
Mhm.
But you see what I'm saying?
Well, I mean, in Deskins, that's a different issue from Deskins, because in Deskins they were properly served. Like the defendant was properly served. At least that's what the court says. We may not like it, right? But that's what the court says. They were properly served, right? And really that wasn't the issue on appeal anyway. That issue didn't get it. But in the situation that we have here, this assumes that there's no service process at all. That's much simpler. Somebody else had anything? No? Got it? Good. Dan? Federal court, a new diversity action for breach of contract. Court finds the breach. Fails to dismiss the complaint, or I'm sorry, court denies the motion to dismiss the complaint, and then defendant fails to file an answer. You file a default judgment here. Already talked about it. What's the answer?
Oh, wait, read it out.
Motion to dismiss has been
Yeah.
denied, right? And then the defendant just totally drops the ball and doesn't file an answer. Yeah, you can. Yeah, you can. Give me chapter and verse. What's the rule?
Failure to otherwise defend.
Well, okay, but what's give me a number followed by a letter followed by another number. 55B2. That's the one. 55B2. That's one. Default judgment has been obtained. Defendant learns that the default judgment has been obtained because we start taking her wages. Oftentimes the way that happens. Doesn't like that. And we've already said, what do you do if you represent her? File a motion to set aside. Right? Depending on how long it's been. File a motion to set aside. Either under 55C, right? Or rather, Rule 60. Okay? All right, can we do this? Yes, this is easy, right? Very simple. Easily done. See what you can do in the last 25 minutes. And this is akin to the kind of thing that I think I'm going to give you on the final exam too, right? Not this exact problem, but something like this. You get the scenario, and you got to figure out what rules apply. Now, obviously, we're talking all day long about default judgment. So I'm probably going to go someplace in Rule 55, something, somewhere, right? You're not going to know that for your final exam. So even though I'm going to allow you to bring anything that's not alive to your final exam, right? So I want it to be as close to a sort of quasi-practice scenario as we can come. You still have to study for that final exam. Because you're going to need to know where to look, or else you're not going to have enough time. So you get something like this, what are you going to do? Well, let's see how your reading comprehension is. Let's see what we come up with, okay?
Next time we can all just work together, right?